Well, folks, KZ has filed. Here's the document. Table of contents, blah, blah, blah. I'm just going to skip to the meat of the bones. Issues presented. Whether the court must conduct review of sufficiency of Mr. Avery's motion for post-conviction relief on its face because of the circuit court's failure to conduct any such analysis as a matter of law. Circuit court answered no. Whether the circuit court improperly imposed a burden on Mr. Avery to conclusively prove the Denny motive element to order satisfies materially prongs. Circuit court answered no. Whether the circuit court erred when it did not correctly apply third-party suspect evidence. Circuit court answered no. Hold on a minute. And there we go. Alright, statement order regarding publication. Appellant requests oral argument to facilitate review of the complex legal issues raised herein. The publication is warranted because of the case is considered public. Introduction. Alright, one moment, please. Alright, when dealing with the stakes as a high defendant liberty, third party prepared evidence walks a bit out of a tightrope. Without regard to Mr. Avery's liberty, even after he has brought forth strong new evidence connecting the third party to Miss Halbach's murder, the circuit court has denied Mr. Avery the opportunity for evidentiary hearing. Mr. Avery now appeals the circuit court denial of his amended third post-conviction motion because the circuit court's opinion is so legally and factually flawed that it does not even consider whether Mr. Avery has alleged sufficient facts warrant the evidentiary hearing. Instead, circuit court inertiously interprets as requiring conclusive proof of the motive to satisfy the materiality requirement and requiring an alleged third-party suspect to have necessary skills to manipulate evidence in manner that the world implicated defendant to satisfy opportunity prong. The circuit court's decision denying Mr. Avery an evidentiary hearing on his new evidence of Bobby Dassey's possession of Miss Halbach's vehicle is based on a rational premise that Bobby could have been in possession of the car that night. To help hide evidence to protect the two individuals directly linked by forensic evidence to the murder and convicted of the crime. Emphasis. First, the circuit court hugely mistaken presupposing that Brendan Dassey was ever linked forensically to the crime. He was not. Second, the circuit court earnestly relies upon evidence that barred from being considered Mr. Avery's trial, such as Brendan Dassey's confession, to support its decision to deny Mr. Avery an evidentiary hearing. The circuit court's speculation that when Bobby moved Miss Halbach's vehicle onto the Avery property, it was his intent to help his uncle by hiding evidence. That is contradicted by the fact that all the forensic evidence used to convict Mr. Avery was in the vehicle and was discovered because the vehicle had been moved onto the Avery property. Mr. Avery's blood and DNA was in the vehicle. Miss Halbach's electronic devices from the vehicle were subsequently found in Mr. Avery's burn barrel, and the RAV4 key was later found in Mr. Avery's bedroom. None of the incriminating. Bunch of footnotes. Skim through. Let's see. Citations, record, appeal, document number before the colon of the page, number, colon, citation, blah, blah, blah. Alright, never mind. Alright, evidence was discovered until the vehicle was brought back to the Avery salvage yard by Bobby. In the circuit court's nonsensical conclusion, because the action could be seen as an effort by Bobby to help Mr. Avery, he cannot be considered a valid third-party Denny suspect. The circuit court failed to explain why, if Bobby was simply lending a helping hand in a homicidal uncle, he would not become a state star witness against Mr. Avery. The statement of the case, procedurally history. The case began in early November 2005 with the disappearance of Teresa Halbach. The 25-year-old professional photographer, Ms. Halbach, was reported missing on November 3rd, 2005. On November 5th, 2005, volunteer searchers found Ms. Halbach's Toyota RAV4 on the 40-acre site of Avery's Auto Salvage, a salvage yard business where Mr. Avery and other family members lived and worked. Ms. Halbach had photographed vehicles in the site previously, per Mr. Avery's request. According to the state witness Bobby Dassey, Ms. Halbach was last seen walking towards Mr. Avery's trailer on October 31st, 2005. After finding Ms. Halbach's RAV4, the law enforcement searched the Avery property and over a course of the next 4 months discovered and identified evidence including burned bone fragments in and around the burn pit with the DNA matching Ms. Halbach's blood in the RAV4, the remnants of electronics devices and the camera, the same models as Ms. Halbach in a burn barrel, Ms. Halbach's RAV4 key in Mr. Avery's bedroom with Mr. Avery's DNA on it. Mr. Avery's DNA on the hood latch of the RAV4, deposited the state later, claimed by Mr. Avery's sweaty hands, and the bullet on Mr. Avery's garage containing Ms. Halbach's DNA. During Mr. Avery's trial, Bobby was the state's primary witness against Mr. Avery. The state and Bobby's testimony established that Ms. Halbach never left the Avery property alive. In his opening statement, Prosecutor Kratz explicitly told the jury of the significance of Bobby's putative observations on the date of Ms. Halbach's disappearance. You're going to hear that Bobby was the last person, the last citizen that would have seen Teresa Halbach alive. During the trial, Bobby testified that he observed Ms. Halbach's SUV pulled up in the driveway at 2:30 p.m. on October 31st, 2005. Bobby testified that he then observed Ms. Halbach exit her vehicle and started taking pictures of the mom's maroon van right in front of the trailer. Bobby testified that he then observed Ms. Halbach walking towards the door of Mr. Avery's trailer. The following exchange occurred between Prosecutor Kratz and Bobby. After seeing the woman walking towards your Uncle Stevens, did you ever see the woman again? Answer, no. On March 18, 2007, Mr. Avery was convicted of first-degree intentional homicide, contrary to Wisconsin Statute 940, and a felon in possession of a firearm, contrary to Wisconsin 94129. The jury found Mr. Avery not guilty of mutilation of a corpse. On October 11, 2019, Mr. Avery appealed the circuit court's denial of his second post-conviction motion and all his supplements. He filed motions to stay and remand concerning 2 additional claims. In the court's direction, Mr. Avery raised his claims in the motions to the circuit court as supplemental post-conviction motion. The circuit court denied his motions to supplement. During the pendency of Mr. Avery's appeal, a new witness, Mr. Thomas Lewinsky, contacted Mr. Avery's current post-conviction counsel in December of 2020. Mr. Lewinsky stated that he witnessed Bobby and another individual, a bearded man, pushing Ms. Halbach's RAV4 onto the Avery salvage yard in the early morning hours of November 5th, 2005. Mr. Lewinsky's claimed that he had reported this information to the Manitowoc Sheriff's Office. On April 10th, 2021, Mr. Lewinsky provided an affidavit to Mr. Avery's current post-conviction counsel stating that Mr. Lewinsky was a motor route driver at Jeanette Newspapers Incorporated and delivered papers to the Avery salvage yard in the early morning hours of November 5th, 2005. Prior to delivering the newspapers to the Avery salvage yard, he turned onto the Avery property and witnessed 2 individuals, a shirtless Bobby, and an unidentified older male suspiciously pushing a dark blue RAV4 down Avery Road towards the junkyard. The RAV4 did not have its lights on. Mr. Lewinsky drove past the 2 men and delivered newspapers to the Avery mailbox. He then turned around and drove back towards the exit. When he reached RAV4, still over there, Bobby attempted to step in front of the car to block him from leaving the property. Mr. Lewinsky came within 5 feet of Bobby, and his headlights were on Bobby during this entire time. Then Lewinsky swerved into a shallow ditch to escape Bobby and exit the property. Mr. Lewinsky states in an affidavit that he called out, "Paperboy, I gotta go," because he was afraid for his safety. He further stated that Bobby looked him in the eye and did not appear happy to see Mr. Lewinsky there. After Mr. Lewinsky learned that Teresa Halbach's car was found later on that day, on November 10, 2005, he realized the significance of what he had observed and immediately contacted the Manitowoc Sheriff's Office. Mr. Avery filed a motion for remand and stay of appeal to court containing Mr. Lewinsky's original affidavit. On July 28, 2021, the court issued a per curiam opinion upholding the circuit court's summary denial of Mr. Avery's raised in his 97406 post-conviction motion supplemental motions, holding that Avery's 97406 motions are insufficient on their face and entitled him to a hearing. However, the court did not remand Mr. Avery's case for circuit court ruling on the claim in the most recent filing concerning the new witness, Mr. Sawinski, and believed Mr. Avery's ability to raise his issue is excessive. Regarding the certain claims, Mr. Avery raised in a motion to consider the Circuit Court's October 3, 2017 order denying his second post-conviction motion and two supplements the court found. Neither we nor the Circuit Court squarely considered whether these claims are procedurally barred under Escalonian or whether Avery pledged sufficient materials entitling him to a hearing. Such consideration would have to come on a separately filed Wisconsin 97406 motion, and we expressed no opinion on whether such claims would be barred in the event such a motion is filed. Therefore, the court did not rule on certain issues contained in Mr. Avery's prior motion to consider in his two supplements. On August 16, 2022, Mr. Avery filed his third motion for post-conviction relief pursuant to 97406. Mr. Avery filed the amended motion on December 6, 2022. Motion set forth newly discovered evidence. The third party, Bobby, was seen in possession of the victim's Miss Hallbach's vehicle after her disappearance. Mr. Sawinski contacted the Innocence Project above the matter in 2016. Although where Mr. Sawinski's original believed it was Mr. Avery's child defense attorney, he was contacted in 2016 after finding the email verification. He realized it was rather the Innocence Project he contacted, and thus he amended his original affidavit, which was submitted in Mr. Avery's motion to stay his appeal. In the court, Mr. Sawinski's amended affidavit was filed in the circuit court, reflecting this mistake. Affidavits from two other new witnesses, Mr. Avery's case, Mr. Kevin Ramlow and Mr. Thomas Bruce, corroborated Mr. Sawinski's observations. In Mr. Avery's 97406 motion, Mr. Avery also raised Brady claims relating to the information from the new witness. Mr. Avery attached affidavits to the document showing that Mr. Sawinski contacted Mr. Avery's current post-conviction counsel and provided newly discovered evidence. Mr. Avery's current post-conviction counsel thought through its investigator, submitted its second public records request pursuant to the Freedom of Information Act for audio recordings of incoming, outgoing calls and radio dispatch between November 3rd, 2005 and November 9th, 2005, relating to the case. The FOIA produced audio recordings that did not contain the Sawinski call, and nor did they contain any dates or times of the calls produced. In May of 2022, Mr. Avery's first post-conviction counsel received a previously suppressed Sawinski call in the Manitowoc County's office, which contained a partial recording of a suppressed call at the Manitowoc Sheriff's Office on November 6th. For the first time, current post-conviction counsel received the exact dates and times of the Manitowoc County Sheriff's Office incoming calls. As part of the investigation, Mr. Avery's investigator then interviewed Mr. Sawinski's ex-girlfriend, whom was dating at the time of November 5th, 2005 incident. Ms. Sawinski's ex-girlfriend, Devin Novak, corroborated Mr. Sawinski's account of what he had witnessed and what he had relayed to the law enforcement. Further, Ms. Novak recognized and identified Ms. Sawinski's voice on the recording played to her by the investigator. For a phone call made by the Manitowoc Sheriff's Office on November 6, 2005 at 10:28 p.m., Mr. Avery investigator interviewed Mr. Sawinski again and played the same audio recording of the phone call that was made to the Manitowoc Sheriff's Office on November 6, 2005 at 10:20 p.m. Mr. Sawinski identified the voice on the audio recording as the phone call from November 6, 2005. The recording of Mr. Sawinski's call was never disclosed by state to Mr. Avery's trial defense counsel prior to during the trial. Pre-trial, trial defense counsel made two specific requests for all exploratory evidence and information within the possession, knowledge, or control of the state which would tend to negate the guilt of the defendant, or which would tend to affect the weight of credibility of the evidence used against the defendant, including inconsistent statements pertaining to the Brady claim, stemming from the evidence from Mr. Ramlow. Mr. Ramlow described in his affidavit that he reported his observation to the Manitowoc Sheriff's deputy he encountered on November 4th at the Senate station on State Highway 147 in Michigan. No law enforcement report was ever generated by the Manitowoc Sheriff's deputy, memorializing the conversation between Mr. Ramlow and the deputy about Mr. Ramlow's opposition in the hollow box vehicle. Circuit Court denied Mr. Avery's motion for post-conviction relief on August 22nd, 2023. Mr. Avery filed a timely notice to appeal to August 24th, 2023. This appeal follows argument whether the circuit court or whether the court must conduct a de novo review of the sufficiency of Mr. Avery's motion for post-conviction relief in the face because the circuit court's failure to conduct such analysis is a matter of law. In the circuit court's opinion dismissing Mr. Avery's third motion for post-conviction relief, the circuit court failed to consider Mr. Avery's request for an evidentiary hearing. The circuit court must determine first whether the motion on its face alleges sufficient material facts, if true, would entitle the defendant to relief. As with any other civil proceeding in assessing the legal sufficiency of the motion, the court must assume that the facts alleged therein be true. Only after the evidentiary hearing is the court charged with determining the issues and making the findings of fact and conclusions of law. The circuit court improperly attempted to weigh Mr. Avery's facts within the speculative theories unsupported by the record, rather than accepting his facts as true and determining whether they were sufficiently pled to warrant an evidentiary hearing. Despite the fact that the circuit court opened its opinion claiming the defendant is back before the circuit court failed to conduct any analysis of whether Mr. Avery's pled sufficient facts to warrant an evidentiary hearing on his newly discovered evidence. Rather, in its opinion, the circuit court weighed Mr. Avery's evidence as it had already been presented during an evidentiary hearing. An evidentiary hearing is nothing more than an intermediate step toward the object of being granted a new trial, and it's not an end to itself. The evidentiary hearing is the forum to prove allegations and a motion for post-conviction relief. Mr. Avery's motion for post-conviction relief states that he is set to prove if he were granted an evidentiary hearing. An evidentiary hearing would prove Mr. Avery with the opportunity to prove his complete claims that he entitled to new trial. Mr. Avery's motion contained all the proof that's necessary to show that he was entitled to a new trial. He would not need an evidentiary hearing. In Mr. Avery's prior appeal, the court, after the circuit court denied his second motion for post-conviction relief, the court properly was guided by the law for determining whether an evidentiary hearing is warranted. The court correctly stated the law where, as here, the defendant appeals the circuit court's denial of Wisconsin state statute motion without evidentiary hearing. Then the question before us is narrow, whether remand for a hearing is warranted because the circuit court erred in denying the motion on its face. The circuit court correctly noted the two potential standards determining whether the circuit court erred in filing a granted evidentiary hearing. The first being the circuit court must hold a hearing with the motion sufficient on its face unless the record as a whole otherwise conclusively demonstrates that the defendant is not entitled to relief. Additionally, the court noted if the motion does not raise sufficient facts or present only conclusory allegations or that the record conclusively demonstrates that the defendant is not entitled to relief, then the circuit court has direction to grant or deny the hearing. In such case, the court views an error's excess of discretion. Here in the circuit court never conducted an analysis on whether Mr. Avery pled sufficient facts to warrant an evidentiary hearing, nor made the request finding pursuant. The record conclusively demonstrates that the defendant is not entitled to relief. This court should reverse the circuit court's ruling denying Mr. Avery's motion because it failed to make the required findings establish case law. The circuit court misapplied State v. Edmonds by requiring Mr. Avery to conclusively establish Bobby's motive to murder Ms. Halbach's motion in its face in order to satisfy the Materiality court. In Edmonds, standard review, an appellate court reviews the circuit court's determination of whether a defendant has established his or her right to a new trial based on newly discovered evidence for an enormous exercise of discretion. The court properly exercises its discretion and relies on the relevant facts in the record and applies the proper legal standard to reach a reasonable decision. Thus, this court will find an enormous exercise of discretion in the circuit court's factual findings are unsupported by the evidence, or if the court applied a no review of the law. Burden of proof on a motion post-conviction relief pursuant to Wisconsin statute The defendant has the burden of proof. The defendant must show an entitlement to relief by clear and convincing evidence. To obtain an evidentiary hearing on the motion for a new trial basis newly discovered evidence, the defendant first must show specific facts that are sufficient by clear and convincing proof and demonstrate that the evidence was discovered after conviction, which is what happened. The circuit court found that Mr. Avery satisfied all the elements required to admit the newly discovered evidence, but for materiality requirements, the circuit court imposed a new Denny requirement that Mr. Avery must establish that the Bobby had motive, established by conclusive evidence, to commit the murder of Miss Halbach to meet Edmund's materiality requirements. Specifically, the circuit court stated, a review of the record and the defendant's argument revealed that he has failed to satisfy the third standard of the Edmunds test, as well as the motive element of the Denny test. With respect to the Edmunds sick test, the defendant argued that the evidence offered was material to his issues because of it. Established that there was a viable third-party suspect that could have committed the murder of Ms. Halbach. Such evidence was never presented to the jury for consideration, undermining confidence of the verdict reached. In order to meet the burden, the defendant had to prove that the evidence also met the standard set forth in Denny and admissible the proof of the third-party suspect. Defendant failed to establish that Bobby the requested motive to commit the murder. It's just like she said, just because Bobby Dassey is spotted with the vehicle doesn't mean he had the key. Yeah, okay. According to the circuit court, Mr. Avery would have satisfied two tests for the circuit court to admit the affidavit of Sawinski into evidence. The circuit court promptly found that the materiality of Mr. Avery's newly discovered evidence is exclusively contingent upon the satisfaction of the Denny test for the admissibility of potential third-party suspect in evidence. In determining that Mr. Avery's new evidence could only be material to the issue of the potential third-party suspect, the circuit court completely ignored the inherent immateriality of the Sawinski evidence to other material issues in Mr. Avery's case. In Mr. Avery's third motion for post-conviction relief, he argued the Sawinski evidence is material to several issues in Mr. Avery's case. It is material for establishing Mr. Avery's defense that he is a third party committed to the crime against Ms. Halbach. Additionally, the Sawinski material is material the evidence of the RAV4 being planted by Bobby, including Mr. Avery's blood, DNA. The RAV4 also contained the Halbach vehicle key and Ms. Halbach's electronic devices were discovered in Mr. Avery's bedroom and the burn barrel, respectively. Further, the Sawinski's evidence is material to impeach Bobby's trial testimony that Ms. Halbach never left the property and that was last seen walking toward Mr. Avery's trailer. The new evidence showing Bobby had possession of Ms. Halbach's vehicle is highly material for evaluating the reliability of the forensic evidence and used against Mr. Avery, which all happened to be derived from Ms. Halbach's vehicle. Crucially, it is also material as reliable as the state's key witnesses against Mr. Avery, Bobby himself. The court pointed out in paragraph 4 of the opinion, July 28, 2021, the state's theory was that Avery shot Halbach in the head in his garage and threw her in the cargo area of the RAV4. He then burned the electronics and camera, cremated Halbach in the burn pit, transferred the remains to the burn barrel, and hid the RAV4 until he could crush it in Avery car crusher. Mr. Avery's new evidence shows that the vehicle did leave the Avery property and was in possession of a third party. Additionally, the new evidence debunks the state's theory against Mr. Avery that he had kept the RAV4 on the property and by the crusher so he could crush it immediately. The evidence that Bobby's possession of Halbach's vehicle was materially because of how that Bobby had possession of the forensic evidence used to convict Mr. Avery. The vehicle was the crime scene virtue by having all the relevant forensic evidence in it, including Ms. Halbach's blood. The Sawinski evidence established that Bobby, the state's star witness, had control of the crime scene for a period of time, despite police searches preceding the discovery of Ms. Halbach's vehicle. Ms. Halbach's electronic devices, the key, were not found until after Ms. Halbach's vehicle was found. The only logical conclusion to explain this is that the items remained in Ms. Halbach's vehicle and were removed by whoever had possession of her vehicle. If a third-party suspect had possession of Ms. Halbach's vehicle, numerous areas of reasonable doubt arise, such as forensic evidence in the vehicle is tainted by the third party having control of it before it was discovered by law enforcement in the Avery property. This would have created reasonable doubt in the jurors' minds, particularly since the state's star witness was one of the possession of the vehicle. Thus, Mr. Avery's new evidence also presents an alternative theory for the source of forensic evidence used against Mr. Avery. It is leading the case in newly discovered evidence. The defendant was convicted of the death of an infant she was carrying for the time of the infant's death. The defendant filed a motion for a new trial over a decade after the trial and offered medical testimony that showed that there had been a shift in mainstream medical opinion as the cause of types of injuries the infant suffered. The court found that evidence material to the issue case because the main issue at trial was the cause of the infant's injuries, and the new medical testimony presented. Right, citing the case. Here, applying Edmonds, Mr. Avery's new evidence is material to a key issue in Mr. Avery's case because Mr. Avery's new evidence that Bobby had possession of Miss Halbach's vehicle after her murder presents an alternative theory for the source of the evidence used to convict Mr. Avery. Swinsky evidence additionally material because it completely calls into question the reliability of the state's key witness, Bobby, testimony, which allowed the state to argue that Mr. Avery had exclusive control of Miss Halbach and her vehicle, which contained all the forensic evidence that convinced the evidence was not tainted by the third party. During its closing argument, the state emphasized the importance of Bobby's testimony and vouched for his credibility. Again, an eyewitness without any bias, it is a individual that deserves to be given a lot of credit. Within the new Swinsky evidence, as well as Ms. Rammel's affidavit, state could not possibly have presented Bobby to establish that Ms. Halbach never left the property in her vehicle and that was last seen walking towards Mr. Avery's trailer. The state's critical witness linked obtaining Mr. Avery's conviction clearly. By Bobby possessing the Halbach vehicle, there's a reasonable likelihood it would have affected the judgment of the jury in that Bobby would have emerged as more likely suspect in the murder of Miss Halbach than originally released. Wrongfully convicted uncle, contrary to the state's representation to the jury, Bobby was biased and deserved no credit for the fabricated testimony. Brady. Additionally, regarding the motion of new trial, reasonable doubt as to the defendant's guilt has been found and exists, and when the reliability of the witness critical to the state's case completely called in question newly discovered evidence. A new trial is required if the false testimony could and reasonably likelihood have affected the judgment of the jury. And has long held that impeaching evidence may have enough to warrant a new trial. In the state, the defendant represented newly discovered evidence that an expert witness lied about his credentials. The Supreme Court of Wisconsin found the case because the testimony was a critical link to the state's case. The expert witness, quasi-medical expert testimony creates a reasonable probability that the jury hearing of this false testimony about the credentials would have reasonably doubt. Blah 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 blah. Here, Mr. Avery presents a stronger case about the materiality of the newly discovered evidence because he does not just allege that it shows that Bobby misrepresented facts in testimony. He alleges that Swinsky evidence shows that Bobby committed perjury in his testimony that he left the property and did not see Miss Halbach again. Furthermore, the newly discovered evidence taints all the forensic evidence used against Mr. Avery, which resulted in the conviction. In his court's previous opinions in July 28, 2021, the court did not believe that the impeachment of Bobby material because they found that there was significant evidence linking Mr. Avery to the crime. However, the Swinsky affidavit established Bobby's possession of the Halbach vehicle undermines the confidence of the reliability of the forensic evidence used against Mr. Avery. This strengthens the materiality of the impeachment against Bobby. In the motion for post-conviction relief, Mr. Avery satisfied Edmonds once the four criteria of newly discovered evidence. Hold on a moment. Hello? Alright, sorry about that. The court's previous blah 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 blah. Okay, so once the affidavit established Bobby's possession of the Halbach undermines the confidence and reliability of forensic evidence used against Mr. Avery. This strengthens the materiality of the impeachment evidence against Bobby. In his motion for post-conviction relief, Mr. Avery satisfied Edmonds once the four criteria of newly discovered evidence have been established. The court looks to whether a responsible probability exists that a different result would be reached in a trial. A reasonable probability factor needed not established by clear and convincing evidence contains its burden of proof. With regard to the motion for a new trial, the correct legal standard when applying the reasonable probability of different outcome criteria which other reasonable probability that a jury, looking at both the old and the new evidence, would be reasonable doubt of the defendant's guilt. A court reviewing newly discovered evidence should consider whether a jury would find the newly discovered evidence had sufficient impact on the evidence presented at trial. A jury would have a reasonable doubt as to the defendant's guilt. Here, the circuit court again failed to analyze Mr. Avery's evidence under the proper test because of the improper requirement Mr. Avery satisfied the Denny motive prong in order to show the materiality of his evidence, even for purposes of Brady. The circuit court did not dispute that the prosecution had suppressed the audio recording of Mr. Winsley's call. Rather, it disputed materially favorably of the evidence to find Mr. Avery failed to establish a Brady violation in respect to the Lewinsky evidence. Rather than making the required finding that there was no reasonable probability that the jury hearing Mr. Avery's new evidence could have reasonable doubt in Mr. Avery's guilt, the circuit court engaged in weighing the evidence of the violent porn found on the dad's computer and concluded that the evidence did not conclusively show that it was solely acquired by Bobby on the computer. In a motion post-conviction relief, Mr. Avery presented evidence implicating the constitutional rights to present the defense and the potential third party committed the murder of Ms. Talbach. However, the circuit court did not correctly apply Denny to the admissibility of Mr. Avery's evidence and potentially third party suspect and erroneously imposed a substantially certainly requirement upon Mr. Avery's evidence to completely misapplied Denny in the evaluation of whether Mr. Avery's evidence satisfied the Denny elements of the motive, opportunity, direct connection. Standard of review: the court generally reviews a trial court's decision and admits to exclude evidence under an erroneous exercise of discretion standard. However, when a defendant's constitutional right to present the defense is implicated by exclusive of evidence, the decision not to admit the evidence presents a question of the constitutional fact of the court reviews. Burden of proof. On the motion of post-conviction relief, the defendant has the burden of proof. Stats must show the entitlement of the relief by clear, convincing evidence. Argument: Denny governs the admissibility of potential third-party perpetrator evidence in Wisconsin that requires a showing. Blah blah blah. In its opinion, dismissed Mr. Avery's motion for post-conviction relief. The circuit court acknowledged that the standard for evaluating the admissibility of evidence of potential third-party suspect is set forth in Denny. However, rather than applying the Denny standard, the circuit court applied to a strict standard, which Wisconsin does not follow. In Denny, Wisconsin Court of Appeals rejected the standard set forth by the California Supreme Court, especially the Denny court design with the Gen court's conclusion that such evidence must be substantial. We are perceived with this is to be strict and standard for the admissibility of such evidence conflicts with our Supreme Court's pronouncements on the fundamental standard of relevancy. Rather than requiring any level of substantial certainty, Denny adopted the standard set forth, blah, 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 blah. If the circuit court had correctly applied Denny, it would have found that Mr. Avery was provided sufficient evidence to satisfy the standard set forth. The Denny court differentiated between evidence with supported legitimate tendency and evidence that simply affords a possible ground of suspicion against another person, which is merely evidence. Denny just showed that hundreds of other people had motive against the blah blah blah, like the okay. Bobby and established a direct connection between Bobby and the crime. Hundreds of others did not have possession of Ms. Holbach's vehicle. Also, have photographs of young and mutilated females on the computer, which they are a primary user. The legitimate tendency test asks whether the profound evidence is so remote in time, placed in circumstances that a direct connection cannot be made between the third person and the crime. Denny does not require a conclusive showing of Bobby's guilt. Rather, it establishes a standard establishing a potential third-party suspect, which is materially issue in any murder case. Denny states as long as the motive and opportunity have been shown, as long as there is also some evidence to directly connect the third person to the crime charged with, does not remote from time, place, and circumstances. The evidence should be admissible. Where Mr. Avery provided the evidence that Bobby Dassey had possession of Ms. Holbach's vehicle after she went missing, he had most likely been conducting computer searches relevant to Ms. Holbach's murder. that was on Avery's property before Miss Halbach's disappearance and after her disappearance. No reasonable tier of fact correctly applied to law would find that Mr. Avery has not established some evidence directly connecting Bobby to the crime charge. The circuit court enormously evaluated the motive, opportunity, and direct connection elements of Denny. As the court pointed out in its opinion previously, the evidence in support of Denny must be viewed by aggregate, and that rather than viewing Mr. Avery's evidence in aggregate, the circuit court required Mr. Avery to present conclusive proof to satisfy each prong individually. However, delicate piece of defendant's profound evidence need not eventually satisfy all three prongs. Further, Wisconsin Supreme Court has determined that the strength of proof of one prongs may affect the evaluation of other prongs. The circuit court completely ignored that these will establish principles of law evaluating the motive, opportunity, direct connection elements. Motive element of Denny in Mr. Avery's motion for post-conviction relief, he alleged that the motive attributed to Bobby for Miss Halbach's murder could have been sexually provided evidence supporting this, namely the suppressed evidence from the computer that in Bobby's bedroom. According to his brother Blaine's affidavit, Bobby was the primary user of the computer. Bobby lied to police about the location of the computer, claiming it was in the living room, but crime scene footage showed it was in the bedroom. The computer was examined and revealed searching highly relevant to the murder of Ms. Halbach, which occurred during the times in which the state had been unable to rule Bobby out as having conducted them. The state argued that the other members of the Dassey household could have conducted searches sufficient of the man to be true, but no other member of the Dassey household was spotted by a witness in Ms. Halbach's vehicle shortly after her disappearance. Bobby's possession of the vehicle with all the forensic evidence used to convict his uncle, combined with the violent pornographic searches on the computer in his bedroom, in which he is the primary user, elevates him to the level of the Denny third-party suspect. The circuit court spent 12 pages of 31-page opinion weighing Mr. Avery's motive evidence, which is improper and contrary to the law and motive. The issue whether the pornographic searches on Dassey's computer. In his opinion, the circuit court noted that the state further disputes that the defendant conclusions that the law enforcement consider pornography or sexual assault as motive for the murder in the matter. In dismissing Mr. Avery's motive evidence, the circuit court adopted erroneous positions from the state's response brief. However, this point is completely refuted by the record. On March 10, 2006, the state filed the amended information against Mr. Avery, adding the charge of sexual assault, among others. The amended charge was the result of Brendan Dassey's confession. On March 1st, 2006, Mr. Avery's trailer and his computer were searched extensively for pornography, and none was found. Detective Veely was asked to generate a report of Mr. Avery's computer. Based on Detective Veely's report, no apparent searches of pornographic or sexual images were made, and no websites where apparent sexual and pornographic images were accessed. In further search evidence to support the sexual assault motive, the Dassey computer was seized by law enforcement on April 21st, 2006. In the affidavit search of the warrant of the Dassey computer, Special Agent Thomas Fassbender testified, your client believes that the said computer may contain images, records, and messages which may be relevant to the investigation into the homicide of Teresa Halbach. Your client further believes that the information contained on said computer may include evidence of crime, so homicide, mutilating corpse, and sexual assault. Again, the circuit court misstated that the evidence, by relying upon the state's misrepresentations of the investigation, was not focused on sexual motive. Law enforcement made great efforts to extract all the pornography from the Dassey computer, and even went so far as to have the detective really conduct a specific word search relating to the murder and effort connecting the pornography and murder. Specific search terms were words with body, throat, bullet, DNA, fire, gas, Rav, gun, handcuff, bondage, blood, tire. The VLC contained state recovered pornography images relevant to the Halbach murder. On the CD, Detective Veely refined 14,099 images on the 7 DVDs and recovered 1,625 violent pornography images that had been deleted. The CD contains thousands of images of violent pornography, criteria, word searches, registry, internet history, Windows history, MSN messages. All of them reveal expressly for sexual violence. Without any evidentiary hearing, it cannot be conclusively established that Bobby was conducting these searches. Yet, Mr. Avery provided sufficient evidence concerning the schedule of the occupants of the dad's residence to eliminate concerned individuals who would have access to the computer from many of the violent burning searches. Mr. Avery has been unable to get an affidavit from Bobby admitting that he conducted the searches, nor someone from the Dassey household stating they saw Bobby perform the searches, which the circuit court seems to be requiring. Moreover, Bobby did not volunteer for a forensic or psychological examination by Mr. Avery's experts, as the circuit court suggests is required. Based upon findings of Mr. Gary Hunt, Mr. Avery's forensic computer expert, 667 sexual content searches were performed in total. Of those searches, 562 were performed on 10 weekdays between 6 a.m. and 3:30. 4 searches, 9:13, 12 searches, 2:23, 48 searches, 3:29, 37 searches on 3:30, 23 searches on 4:3, 93 searches on 4:5, 96 searches on 4:6, and most of these searches, Brendan's not there, so it's either Blaine or Bobby, and my money's on Bobby. Therefore, 64 sexual contact searches were performed prior to Ms. Halbach's murder between 6 a.m. and 3:45 when Bobby was allegedly home alone. If the family's reported sex schedule are taken to be true, another 500 searches were performed in this same time frame after the murder when Bobby was supposedly home alone. It's in response to Mr. Avery's motion for post-conviction relief that the state concede that Bobby is at least connected to 3 of the most violent searches prior to Mr. Halbach's murder, and eventually considered that Bobby is connected to the 25 of the searches after Ms. Halbach's murder. Bobby cannot be eliminated by the state from any of the preliminary searches, especially the ones conducted prior to and very close in time to Ms. Halbach's murder, and he is the only family member who has seen Ms. Halbach's vehicle after her disappearance. The circuit court earnestly concluded that the searches done after Ms. Halbach's murder have no weight. However, conduct a suspected person after the crime is a legitimate subject for consideration and bearing upon the probability of his guilt. Motive can manifest itself after the crime, with perpetrator revealing and fantasizing about the crime, and continued searches for violent pornography demonstrate that the motive for the murder or sexual assault is highly sufficient, and the searches for deceased, mutilated young women being after and not before the murder and mutilation of Ms. Halbach. The searches after the murder coincide with the fact that the young woman was murdered and mutilated. The searches before the murder coincidence the 1,000 images, young women engaging in sexual activity, many unwillingly, and corroborate a sexual assault motive. The circuit court also completely ignored Mr. Avery's evidence of the Dassey computer deletions, which infers the conclusion of guilt. Sufficiently many of the Dassey computer searches have been deleted, and only some of those were recovered, which led to the questions of such as who in the Dassey household deleted the searches, why were these searches deleted before Mr. Avery's trial. To make the proper credibility findings on this issue, an evidentiary hearing must be held. Is highly sufficient in the investigation of the attempt to delete or destroy records. In a sexual assault case, the appellate court found constituents of the guilt and the evidence has been victims delete the next messages and exchanged. The jury heard evidence from which it could infer the murderer deleted the files were messages stating on the case. Mr. Hunt identified 8 times that there was deletions of the Dassey computer. Those deletions are very important because the colorate and Miss Halbach's visits. I knew that. As Halbach visited the property on August 22nd, 2005, there are deletions on the Dassey computer on August 23rd, August 26th. She visited the property on August 29th. There are deletions on August 28th through September 11th. She visited the property on September 19th, and there's a deletions of September 14th through 2005 through September 15th, 2005. There are also deletions from December 24th, 2005 to October 24th, 2005. Most significantly, around the time of the murder, October 31st, 2005, there were deletions from October 26th to November 2nd. Beginning from November 3rd, 2005, there were further deletions made on the Dassey computer. These deletions at the above described relevant times cannot simply be dismissed or mere coincidences. The circuit court misconstrued the holding by adopting the state's argument that the pornographic images must be a mirror image of the crime or they have no relevance. The court in Brooklyn made such ruling and held that the pictures depicting violence were offered to provide us with fascination with the death and mutilation, undeniably provocative motive, intent to plan to commit vicious murder. Likewise, there has been dash computer pornography consists of images depicting violence that show a fascination with death and mutilation, and the trait that the Dashi pornographic consumer is undeniably probative of motive, intent, to plan to commit vicious murder. Mr. Avery provided the circuit court with specific searches on the Dashi computer of terms such as someone who was shot, and searches for a gun to head. There were 8 searches prior to Ms. Hallbach's murder on 9/17 for a skeleton, a live skeleton. After the murder, there were 6 searches for girls' guts and 15 searches for girl hurt and 2 searches for seeing bones, hot girls. These searches mirror the fate of someone hurt, shot in the head, mutilated, burned into skeleton remains, which is the total amount of information known about Miss Hallbach's fate. More importantly, these images reveal the trait of the Dashi pornographic consumer that is probative to the motive, intent to plan to commit a vicious murder. Contrary to the circuit court's view, the proper standard does not require Mr. Avery to establish as evidence of Bobby Dassey's motive and absolute certainty. In the fact that level of certainty has been required by a court of Wisconsin to satisfy a motive element of Denny can element of Denny analysis for the matter. Under the motive of prong, the court simply must question whether the alleged third-party perpetrator and plausible reason to commit the crime. Evidence of general motive is sufficient to prove prong Denny first. Further, because motive is never an element of any crime, and the state never needs to prove motive relevant to evidence, the motive is generally admissible. Mr. Avery's third-party motive evidence is relevant regardless of the weight assigned to it by the circuit court. This is precisely in line with the court's prior guidance of Mr. Avery's new direct connection evidence survives scrutiny and its merit. The motion evidence found in the VLCD might become relevant to showing Bobby Dassey motive, might bear on whether Dassey is or should have been variable Denny suspect. Moreover, the circuit court failed to consider the motive evidence, although not conclusive, in conjunction with Mr. Avery's new evidence, which established a direct connection between Bobby and the crime. Mr. Avery offered the motive evidence in conjunction with the evidence of Bobby's opportunity and direct connection to Miss Hallbach's murder, and framing Mr. Avery evidence of the motive that would be admissible against the third party, where the third party is the defendant. It is therefore admissible when offered by the defendant in conjunction with the evidence of the third party opportunity and direct connection. In rehearsing the weight, Mr. Avery's prior evidence of the motive contained in the VLCD, with this court already assessed was not sufficient in any other itself, could be relevant to Mr. Avery. To show Mr. Dassey direct connection, the circuit court evaluated the CD evidence in isolation, contrary to the circuit court's prior directive in remanding the case, where the Wisconsin Supreme Court determined that the strength and proof of one of the prongs may affect the evaluation of other prongs. Here, Mr. Avery's powerful direct connection evidence certainly affects the evaluation of the other prongs because it provides evidence supporting all 3 prongs of Denny test. For example, even if the motive of Ms. Hallbach's murder was not sexually, as law enforcement believed, the Sawinski evidence offered evidence that the motive could have been robbery. The circuit court finding that Mr. Avery had not established the motive element to the odds of Wisconsin case law. Wisconsin cases that discuss the motive element of the Denny analysis show that the standard for fulfilling the motive element of Denny is not overly burdensome, especially when there is strong evidence of the third party perpetrator's direct connection to the crime. Direct connection, thus, and found plausible reasons for the third party to commit the crime. In Ramsey, the victim was found stabbed at home. 911 caller told police that the victim had stayed at her sister's home to hide the defendant. The defendant had been in a relationship with the victim for 11 years and 2 children. Okay, I'm not reading all that. Okay, opportunity limit Denny, and regarding the opportunity limit Denny, burden respect to element to opportunity to the same test. It is undisputed that Bobby was on the Avery family property when Miss Hallbach was there and before and after she was reported missing. Nor really even proximity to the murder is sufficient to show opportunity. However, the circuit court improperly imposed the burden on Mr. Avery to prove that Bobby had the skills, contacts, tools, time, and other means necessary to have committed the crime, staged the scene in order to satisfy the opportunity element of Denny. The circuit court cited for its own finding that Mr. Avery had proved potential third party had skills, contacts, tools, blah blah blah, and committed the crime stated to the scene, manner alleged. However, in reality, the principle came from the Kansas Court of Appeals case that the state cited as response brief. Even if the principle was from the Kansas case where somehow applied to Wisconsin, the fact that Kreider is completely inappropriate to the Mr. Avery's case, and in Kinder, the defendants proffered evidence in a potential third-party perpetrator consisted of alleging a potential motive for the victim's son-in-law to kill her and the son-in-law's wife would benefit from the inheritance. The son-in-law could have opportunity to prevent its hair from the headgear of the blood from the use of bandages. Alright, rather than considering the principle from the Kansas case nor Wisconsin one, the circuit court imposed a burden on Mr. Avery to demonstrate that the Bobby had scientific knowledge to plant evidence. The facts of Wilson are completely in opposite of the Avery case. Multiple eyewitnesses identified the defendant as a shooter. The defendant attempted to argue that someone else was a shooter or proffering evidence of alleged potential third-party perpetrator. However, the potential third-party perpetrator was completely unknown because the defense theory was that a hitman was hired by the man in the car with the victim to kill the victim, and the hitman shot the victim. The court found that there was no evidence showing that the man in the car was the victim, and the opportunity to hire the hitman and agree from among at the time was in the car with the victim before they were shot. The defense failed to present any evidence, contacts, influences, finances used to hire the hitman, yada 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 yada. Importantly, Wilson is not a case about planting evidence or framing. Specifically, the type of theory only requires a showing of access to the frame, starting the following. If the defense theory is a third-party frame of the defendant, then the defense might show opportunity to demonstrate the third party's access to its items supposedly used in the frame-up. However, the circuit court earnestly reasons that the pursuant wisdom Mr. Avery must prove that Bobby had the scientific knowledge to recognize the significance of each piece of forensic evidence supposedly planted by him, let alone establish that he had skill to plant the evidence in a way that would stand up to scientific scrutiny by professional crime scene analysis. This is not standard for showing the third party framed the defendant. The evidence that the third party had access to the items used in framing up is sufficient pursuant to Wilson. Avery's standard for satisfying the opportunity element, Denny and there before, applied to Wisconsin. State v. Valorect. In the case in which the evidence of connection to the motive carried the strength of the opportunity evidence, the trial court granted the defendant new trial. Appellate court. Alright, this is her just citing a whole bunch of cases. I'm going to leak the link to this document into the description of the video. So, otherwise, you can also go on KZ's website and you can get it there. 20 years after his conviction, the defendant filed a motion for a new trial based on newly discovered evidence. The third-party perpetrator had been convicted of similar killing only 6 weeks later. The new addition, this is her citing more cases. In Mr. Avery's case, the opportunity element already been decided previously by courts. According to Mr. Avery's trial court, Mr. Avery's trial defense counsel already established that Bobby had opportunity to commit the murder of Miss Halbach because of the presence of the property at the time Miss Halbach was there. Moreover, Mr. Avery's new evidence could not present a better case for showing that third parties access to accordingly evidence of a frame-up. The Sawinski evidence greatly strengthened Mr. Avery's evidence that Bobby had the opportunity to commit Miss Halbach's murder because it shows that Bobby was in possession of Miss Halbach's vehicle where her murder likely occurred. He had access to Miss Halbach's vehicle and all the evidence used to convict Mr. Avery of the murder. If the defense theory is that the third party framed the defendant, then the defense might show opportunity by demonstrating the third party access to items supposedly used in the frame-up. Mr. Avery's asked his opportunity because of the proximity of the murder, but also because he had access to the items used in the frame-up. The defense theory of the third party's involvement will guide the relevance analysis opportunities of evidence in Denny. It is not the circuit court's theory that guides the analysis. Rather, Accepting this, the circuit court found that Bobby needed some kind of expert scientific knowledge to plant the evidence that had access in the vehicle. However, there is no scientific knowledge necessary to know that planting someone else's blood in the vehicle of a woman that went missing would be incriminating. However, sense would suffice. The circuit court did not explain what special skills it took to shoot Miss Halbach in the head that Bobby lacked. All that was required was to pull the trigger. Bobby was a skilled deer hunter with a .22 rifle. He had obviously pulled many triggers in terms of planting evidence. With the blood, the only skill that would be required is taking a wet sponge and removing it. Mr. Avery's blood from the sink, dripping 1.2 millimeters into the RAV4 and applying it into the dashboard with the household items such as a Q-tip. Mr. Avery told law enforcement in a recorded interview that his finger, which had been cut open prior to October 31st, 2005, rebled on November 3rd, 2005, and dripped blood in his bathroom sink on the bathroom floor. He also bled in his car. He bled all over the trailer that he reopened his cut on, bled in his truck, bled everywhere. And November 3rd, executing onto the highway and were suddenly observed taillights on the vehicle close to his trailer. Mr. Avery told trial defense counsel he noticed that the blood had been removed from his sink when he entered the bathroom early in the morning on November 4th, 2005. The bullet fragment found on Mr. Avery's property simply had to be rubbed in Miss Halbach's blood or on the skin cells, both of which her murderer had access to before it was burned. The court determined that the state did not argue that the specific bullet entered Halbach's skull or killed her, and there were no bone fragments on the bullet, and it is undisputed that there were bullets all over Mr. Avery's property from Rollie Johnson shooting gopher holes with his .22 rifle, as well as Jody Sikowski's firing. And there's facts. There's a phone call where Jody and Steven are talking about her shooting that .22 at Stephen Avery's burn barrel, and what do you know? There's bullet holes in Stephen's burn barrel. She also states that she was the last person to burn something in Stephen's burn barrel, and she was burning her old clothes. The fact that there were burn barrels at the Dassey property, 4 in total, and one which contained human bones, show that the Dassey, which includes Bobby, were proficient in burning material in the burn barrel. Part of the circuit court's interpretation of Mr. Avery's guilt is based on another factual error, a belief that all of Miss Halbach's bones were found in Avery burn barrel. They were not. They were found in a Dassey burn barrel. Dr. Eisenberg claimed that when she opened the container of the bones from Dassey burn barrel, she got a waft of flammable liquid or fluid, but did not smell burned rubber from tires, which the state claimed that the accelerant Mr. Avery used. The evidence suggested Miss Halbach's body was burned in a Dassey burn barrel and dumped in Mr. Avery's fire pit. Common sense suggested Mr. Avery would not have been planting evidence to incriminate himself. The circuit court erroneously stated that Mr. Avery argued that Bobby planted the key in the victim's RAV4 in Mr. Avery's trailer between November 3rd and November 5th. There was no such argument made. Bobby would have had the key and would be planted in Ms. Halbach's vehicle on November 5th because it is undisputed that the RAV4 was locked when it was discovered, so whoever left the vehicle on the Avery property necessarily had the key and locked the vehicle. Bobby had access to Mr. Avery's unlocked trailer from early Saturday morning, November 5th, until shortly before noon when the vehicle was located at the Avery property and was secured by law enforcement. Mr. Avery and his mother left for Cribbet's cottage around early Saturday morning, right around 6:30, along with Brian Dassey. According to the circuit court criteria, Mr. Avery was even less qualified to commit the murder than Bobby by the comparison in terms of his education. He was less educated than Bobby, never having graduated from high school. He was less skilled than Bobby because he never held a job because of wrongful conviction, where Bobby is employed as a third shift worker at a furniture factory during all the years Mr. Avery was incarcerated for his first wrongful conviction. Bobby had been honing his skills in stalking, hunting, killing, burning, and dismembering game. After misapplying Wilson, circuit court earnestly. He also is partner on a YouTube channel. Circuit Court earnestly proposed that the forensic evidence against Mr. Avery stood up to scientific scrutiny. Mr. Avery's trial, Mr. Avery's defense team never represented the required experts to attack the significant evidence. Mr. Avery, as the section post-conviction motion, presented voluminous evidence from numerous experts that the forensic evidence which was used to convict Mr. Avery was vulnerable to being discredited if the defense actually presented all of the experts that the trial defense failed to present, such as DNA, trace, blood, splatter, fire, forensic, pathologists, and ballistics experts. The court determined certainly that these conclusions tend to support every generally theory that was framed as presentation was useful at the trial, but concluded that Avery's experts had failed to show how the introduction at trial could reasonably have led to a different outcome. Now this court has a direct link between the third-party suspect and forensic evidence. The court can consider Mr. Avery's forensic expert opinions in light of the identification of the specific third-party suspect in determining if this evidence could reasonably have led to a different outcome. For example, Mr. Avery's blood splatter expert described that the blood pattern distribution in the vehicle has been inconsistent as coming from active bleeder, as the state claimed. Knowing Bobby had access to Mr. Avery's sink with blood in it and now simply would be selectively drip the blood in the vehicle, and the court should reconsider the blood splatter expert's affidavit. Mr. Avery's DNA expert described that in the control experiments that conducted Mr. Avery's holding of the key for 12 minutes, there was 10 times less DNA deposited on the exemplar key that was presented from Mr. Avery than the vehicle key found in Mr. Avery's bedroom. The expert suggests that the DNA on his key was enhanced some personal item Mr. Avery was used. Now, like I've said, when Jody is released from prison and is living in the trailer, she finds Stephen Avery's toothbrush underneath his sink. He has no idea how it got there. Mr. Avery is not abandoning his theory that the allegedly collected groin swab from Mr. Avery's was substituted for the hood latch swab when they were delivered to the Wisconsin State Crime Lab. However, for purposes of demonstrating that Bobby had the skill necessary to plant DNA on both the hood latch and Mr. Hallbach's key, Mr. Avery asserts that Mr. Avery's toothbrush could have been, wow, how about that, rubbed on both. Both had access to the trailer with the toothbrush prior to the disappearing. Direct connection element to Denny. No bright lines can be drawn as to whether the connection to the third party direct connection to the crime. Rather, circuit court must access the profiled evidence with all other evidence to determine whether under the totality of the circumstances evidence. In its opinion, the circuit court argued that Sawinski's affidavit, taken as true for the purpose of the motion, directly links Bobby to possession of the victim's vehicle. However, possession of the vehicle does not directly link Bobby to the homicide itself. Then the circuit court highlighted that the fact that Mr. Sawinski's affidavit does not mention seeing Bobby with the key to the victim's car, it ignored the fact that Ms. Hallbach's vehicle was found by law enforcement and the volunteer searches. It was locked. Clearly, Bobby had the key to the vehicle. Further, the circuit court ignored the fact that forensic evidence used to convict Avery was discovered after Bobby was seen moving Miss Hallbach's vehicle onto the Raver property. The appellate court found a direct connection between the perpetrator and the murder and the fact that the possession of the victim several days after the murder. Specifically, the court explained, we agree with the state that from the circumstances under a common sense, non-technical approach, reasonable police officer would draw the reasonable inference that both Williams and Armstead had been in possession of the brown stolen car. Okay. Applying to the common sense approach, Sawinski evidence provides a direct connection that is Bobby being witnessed in possession of Miss Hallbach's vehicle to Bobby having committed the murder of Miss Hallbach's, planting the evidence to Mr. Avery. Rather than recognize the experience of evidence that Bobby had possession of, thus access to Miss Hallbach's vehicle, the circuit court required Mr. Sawinski to see Bobby in possession of the electronics inside Miss Hallbach's vehicle. However, the reasonable inference that can easily be made that because the electronics had not been found by law enforcement when Bobby was seen by Miss Sawinski, Miss Hallbach's vehicle, it would still be inside the vehicle. Wisconsin Supreme Court found that the light of Denny and Chamber, blah, blah, blah. Last person, defendant sought an introduction, victim, this is just another case they're citing. And the same reason applied in Mr. Avery's case, the circuit court would have found that the far stronger evidence, direct connection to allow the defense to present Bobby as a potential third-party suspect. The Sawinski evidence connects Bobby to Ms. Halbach's murder in the same ways that the hearsay evidence did to the third party. It established that Bobby lied to the investigators about his whereabouts during the times relevant to determining Ms. Halbach's murder, knowing, of course, the exact time Ms. Halbach's murder is not known. Like Mass, who observed carrying a paper bag after the murder, which was Wisconsin Supreme Court found as material, Bobby was seen with the victim's vehicle after Ms. Halbach's murder, and the evidence certainly put Bobby in close proximity to the location where the homicide is alleged to have occurred, and that combined the evidence showing that Bobby, according to his own testimony, was the last person, one of the last people to see Ms. Halbach alive, would have satisfied Denny had the circuit court applied the reasoning in that. Supreme Court, Wisconsin offers illustration and example what the type of evidence can show. Direct connection to the degree certainly required by legitimate tendency to set to admit the evidence regarding the third party suspect. By illustration, it was shown that the third person not only had the motive and opportunity to commit the crime, but also placed in such a proximity to the crime was shown as to have been guilty party. Evidence is admissible. Even if the circuit court's numerous factual errors were correct, and Brendan Dassey was directly linked by forensic evidence to the murder, and his confession was admissible against evidence against Mr. Avery, it still doesn't allow the circuit court to dismiss the powerful evidence of the third-party direct connection of the murder. Overwhelming evidence against the defendant may not serve as the basis for excluding evidence of the third parties. By evaluating the strength of only one party's evidence, no logical conclusion can be reached regarding the strength of contrary evidence offered by the other. Conclusion. For the reasons stated herein, Mr. Avery respectfully requests that the circuit court grant him one of the following alternative remedies: reverse the orders denying post-conviction relief and grant the evidentiary hearing, reverse the judgments of conviction and order denying post-conviction relief and remand for a new trial, and 3, grant any other relief court deems appropriate. Signed on this date, 1/12/2024, by Kathleen Zellner and her associates. Blah, 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 blah. So, y'all got any questions before I go? Well, appreciate the ones tuning in right now, and I guess I'll see y'all next time.